Obligations and contracts under the Civil Code of the Philippines. Obligation, definition. It is a juridical necessity to give, to do or not to do. Note: positive obligation, to give and to do. Negative obligation, not to do. Essential elements. 1. Juridical tie, the legal or juridical relationship, the unifying bond. 2. Active subject, the obligee or creditor, the party who has the right to demand the performance of the obligation. 3. Passive subject, the obligor or debtor, the party who has the duty to perform the obligation. 4. Prestation, the obligation to be performed, to give, to do or not to do. Note: the obligation must contemplate an active subject and the obligation must be capable of pecuniary estimation. Sources of obligation. 1. Law, taxes, marital, parental obligations. 2. Contracts, sale, lease, simple loan. Equal strengths, obligations created by law and by contracts. Contract has the force and effect of law between parties. 3. Quasi-contracts, solutio in debiti, to return what has been paid by mistake, and negotiorum hestio, to reimburse the officious manager because of the benefit obtained. 4. Quasi-delicts, negligent torts, obligation to pay damages. 5. Delicts, reckless imprudence resulting in damage to property. An obligation imposed on a person, and the corresponding right granted to another, must be rooted in at least one of these 5 sources. The mere assertion of a right and claim of an obligation in an initiatory pleading, whether a complaint or petition, without identifying the basis or source thereof, is merely a conclusion of fact and law. Breaches of obligations. Types of obligations according to prestation. Personal obligations, obligations to do, lease, partnership. Real obligations, obligations to give, contract of loan, mutuum, deposit, perfected by consent and delivery of the property. Without delivery, not perfected. Transmissibility of rights and obligations. Generally, rights and obligations are transmissible, except those that are personal to the party. Examples of rights and obligations that are intransmissible. Rights and obligations of the bailee in a contract of comodatum. Rights and obligations of the parties in a contract of agency. Rights and obligations of a partner in a partnership. Remedies for breach of obligation. Specific performance/sum of money. The debtor must perform what she is obliged to do. Obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. Art. 1159, Civil Code. Rescission. Subsidiary remedy, if the first remedy, specific performance/sum of money, cannot be had. Implied in reciprocal obligations, Art. 1191, Civil Code, there's no need to stipulate if the contract involves reciprocal obligations, parties are both active and passive subjects to each other. Case, requires substantial breach. The policy of the law is to sustain the contract and allow the obligor to perform the obligation. Availed only when the creditor has no other recourse. If foreclosure of mortgage is available, rescission cannot be had. Doctrine of anticipatory breach. Exception to the rule that rescission is only subsidiary to specific performance and substantial breach. Debtor made it clear that he can no longer perform the obligation. Under this doctrine, an unqualified and positive refusal to perform a contract, though the performance thereof is not yet due, may, if the renunciation goes to the whole contract, be treated as a complete breach which will entitle the injured party to bring his action at once. Fraud. When present, it can either annul the contract, 1130, or make the obligor liable for damages, 1170. Dolo causant. Art. 1130, it is a kind of fraud which determines or is the essential cause of the consent. Deception without which, the other party could not have entered the contract. Ground for annulling the contract. Dolo incident. Art. 1170, it is a kind of fraud which does not have such decisive influence and by itself cannot cause the giving the consent, but refers only to some particular or accident of obligation. Ground for payment of damages. Different kinds of obligations. Kinds of obligations. 1. Pure and conditional obligations. Pure obligations, those whose effectivity or extinguishment does not depend upon the fulfillment or non-fulfillment of a condition or upon the expiration of a term or period. It is demandable at once. Conditional obligations, those whose effectivity depends upon the fulfillment or non-fulfillment of a future and uncertain fact or event. Note, by default, if there are no conditions attached, obligations are pure and demandable at once. Kinds of conditions. Suspensive conditions. A suspensive condition is a condition the fulfillment of which gives rise to an obligation of the party in whose favor the condition is created. Example, full payment of the purchase price in a contract to sell. Obligation that is suspended is the obligation of the seller to deliver or transfer ownership. Resolutory conditions. Pure obligation because it is demandable at once but it will terminate upon the happening of the resolutory condition. A resolutory condition is one which extinguishes rights and obligations already existing. Example, in a pacto de retro sale, the repurchase by the previous owner extinguishes the previous sale. Potestative condition, one that depends upon the exclusive will of one of the parties. Under Art. 1182 of the Civil Code, it is considered void. Note: where the potestative condition is imposed not on the birth of the obligation but on its fulfillment, only the condition is avoided, leaving unaffected the obligation itself. 2. Obligations with a period. An obligation with a period is one whose consequences are subjected to the expiration of a period or term. Only affects the demandability. Unlike in conditional obligation, obligation is not yet due unless fulfilled. When debtor loses the right to use the period, Article 1198. In these instances, the creditor has lost trust and confidence with the debtor. There's no need for stipulation. When after the obligation has been contracted, he becomes insolvent, unless he gives a guarantee or security for the debt. When he does not furnish to the creditor the guarantees or securities which he has promised. When by his own acts he has impaired said guarantees or securities after their establishment, and when through a fortuitous event they disappear, unless he immediately gives new ones equally satisfactory. When the debtor violates any undertaking, in consideration of which the creditor agreed to the period. When the debtor attempts to abscond. Art. 1198, Civil Code. 3. Alternative obligations. There is more than one obligation, the performance of one is sufficient. The debtor has the right of election, and the choice is effective when it is communicated to the creditor. If the creditor is given the right of election, the obligation ceases to be alternative from the time the creditor communicates his choice. Distinguished from facultative obligations. 4. Facultative obligations. It is a facultative obligation when only one prestation has been agreed upon, but the debtor may render another in substitution. Case: the obligation between the parties was an alternative obligation. In an alternative obligation, there is more than one object, and the fulfillment of one is sufficient, determined by the choice of the debtor who generally has the right of election. The right of election is extinguished when the party who may exercise that option categorically and unequivocally makes his or her choice known. 5 and 6. Joint and solidary obligations. In a joint obligation, each obligor answers only for a part of the whole liability, equal liability. In a solidary or joint and several obligation, the relationship between the active and the passive subjects is so close that each of them must comply with or demand the fulfillment of the whole obligation. Note: presume in favor of joint obligations. When the law imposes solidary liability. Liability for quasi-delicts. Liability of co-principals in a contract of agency. Liability of partners and the partnership in wrongful acts committed against third persons. Liability of two or more bailees in a comodatum. Corporate officers are solidarily liable with the corporation for the illegal termination of services of employees if they acted with malice or bad faith. Effects of solidarity obligation. In active solidarity, or where there is solidarity of creditors, each creditor is empowered to exercise against the debtor not only the rights which correspond to him, but also all the rights which correspond to the other creditors, with the consequent obligation to render an accounting of his acts to such creditors. In passive solidarity, or where there is solidarity of debtors, each debtor is liable for the payment of the entire obligation, with the consequent right to demand reimbursement from the others for their corresponding shares once payment has been made. 7 and 8. Divisible and indivisible obligations. Divisible obligations are which have for their object the execution of a certain number of days of work, the accomplishment of work by metrical units, and others which are susceptible of partial performance. Indivisible obligations are obligations to give definite things and those which are not susceptible of partial performance. Note, whether it is divisible or indivisible depends on the law or the intention of the parties. Case. Even though the object or service may be physically divisible, an obligation is indivisible if so provided by law or intended by the parties. Obligations with a penal clause. The penalty shall substitute the indemnity for damages and the payment of interests in case of non-compliance, if there is no stipulation to the contrary. Nevertheless, damages shall be paid if the obligor refuses to pay the penalty. The obligor is guilty of fraud in the fulfillment of the obligation. Extinguishment of obligations. 1. Payment. 2. Loss of the thing due. 3. Condonation. 4. Confusion. 5. Compensation. 6. Novation. 1. Payment. Payment is a mode of extinguishing obligations, and it means not only the delivery of money but also the performance, in any other manner, of an obligation. Requisites of payment. 1. Integrity of payment. The thing or service in which the obligation exists must be completely delivered or rendered. Identity of payment. The very thing, service or forbearance must be performed. Indivisibility of payment. The creditor cannot be compelled partially to receive the prestations in which the obligation consists. Neither may the debtor be required to make partial payments. Payment shall be made in the legal tender. However, the parties may agree that the obligation or transaction be settled in another currency. A check may be used for the exercise of the right of redemption, the same being a right and not an obligation. The tender of a check is sufficient to compel redemption, but is not in itself a payment that relieves the redemptioner from his liability to pay the redemption price. When the debtor may pay to a third person, it has redounded to the benefit of the creditor, or the third person is in possession of the credit in good faith. Payment by cession versus dation in payment. Ion in payment, dation and pago, instead of money, which is the original obligation, the debtor pays a determinate thing and the creditor accepts that as full satisfaction of the credit of money. B. Payment by cession. One debtor, several creditors. This takes place when the debtor cedes or assigns his property to his creditors in payment of his debts. The initiative comes from the debtor, but it must be accepted by the creditors in order to become effective. A voluntary assignment cannot be imposed upon a creditor who is not willing to accept. Tender of payment and consignation. Distinction. Tender of payment is the manifestation of the debtor to the creditor of his decision to comply immediately with his obligation. Consignation is the act of depositing the thing due with the court or judicial authorities whenever the creditor cannot accept or refuses to accept payment, and it generally requires a prior tender of payment. Requisites of valid consignation. 1. There was a debt due. 2. The consignation of the obligation had been made because the creditor to whom tender of payment was made refused to accept it, or because he was absent or incapacitated, or because several persons claimed to be entitled to receive the amount due, or because the title to the obligation has been lost. 3. Previous notice of the consignation had been given to the person interested in the performance of the obligation. 4. The amount due was placed at the disposal of the court. 5. After the consignation had been made, the person interested was notified thereof. When prior tender of payment is excused, When the creditor is absent or unknown, or does not appear at the place of payment. When he is incapacitated to receive the payment at the time it is due. When, without just cause, he refuses to give a receipt. When two or more persons claim the same right to collect. When the title of the obligation has been lost. 2. Loss of the thing due. A. In obligations to give, loss, as a mode of extinguishing an obligation, depends on the thing involved. If the thing is determinate, the obligation is extinguished. If the thing is generic or indeterminate, the obligation is not extinguished following the principle of genus non quam perit, or the genus of a thing can never perish. B. In obligations to do, the obligation is extinguished when the prestation becomes legally or physically impossible without the fault of the obligor. Rebus sic stantibus, a legal doctrine allowing for a contract or a treaty to become inapplicable because of a fundamental change of circumstances. Art 1266. The debtor in obligations to do shall also be released when the prestation becomes legally or physically impossible without the fault of the obligor. Art 1267. When the service has become so difficult as to be manifestly beyond the contemplation of the parties, the obligor may also be released therefrom, in whole or in part. 3. Condonation. Condonation or remission of debt. It must be gratuitous. It must be accepted by the debtor. The obligation must be demandable. Note, it may become that ion in payment when the creditor receives a thing different from that stipulated, it may become novation when the object or principal conditions of the obligation should be changed, and it may become a compromise when the matter renounced is in litigation or dispute and in exchange of some concession which the creditor receives. 4. Confusion. Confusion or merger of rights. It is the merger of the characters of the creditor and the debtor in one and the same person by virtue of which the obligation is extinguished. Requisites. That the characters of creditor and debtor must be in the same person. That it must take place in the person of either the principal creditor or the principal debtor. It must be complete and definite. 5. Compensation. It is the extinguishment in the concurrent amount of the obligation of those persons who are reciprocally debtors and creditors of each other. Types. 1. Legal. 2. Voluntary or conventional, by agreement. Requisites of legal compensation. 1. That each one of the obligors be bound principally, and that he be at the same time a principal creditor of the other. 2. That both debts consist in a sum of money, or if the things due are consumable, they be of the same kind, and also of the same quality if the latter has been stated. 3. That the two debts be due. 4. That they be liquidated and demandable. 5. That over neither of them there be any retention or controversy, commenced by third persons and communicated in due time to the debtor. Requisites of conventional compensation. Same kind. Creditor and debtor of each other. That each of the parties can dispose of the credit he seeks to compensate. That they agree to the mutual extinguishment of their credits. 6. Novation. It is the extinguishment of an obligation by the substitution or change of the obligation by a subsequent one which extinguishes or modifies the first, either by changing the object or principal conditions, by substituting another in place of the debtor, or by subrogating a third person in the rights of the creditor. Expromission and delegation distinguished. Novation by substitution of debtor. Substitution by expromission, the initiative of the change does not come from and may even be made without the knowledge of the debtor. It consists of a third person's assumption of the obligation. Substitution by delegation, the debtor offers, and the creditor accepts, a third person who consents to the substitution and assumes the obligation. In both cases, novation by substitution of debtor must always be made with the consent of the creditor. Legal and conventional subrogation. Subrogation. It is the transfer of all the rights of the creditor to a third person, who substitutes him in all his rights. Types of subrogation. Legal subrogation is that which takes place without agreement but by operation of law because of certain acts, e.g. in insurance payouts or indemnities where the insurer is subrogated to the rights of the insured against the third person who caused the damage or injury. Conventional subrogation is that which takes place by agreement of the parties. Conventional subrogation extinguishes the obligation and gives rise to a new one. That's all for obligations. Next video is part 2, which is about contracts. Thank you for watching. Subscribe to my channel for more updates.